live-in relationships and the legitimacy of the children out of live-in relationships. When deciding an earlier case concerning the legitimacy of child born out of wedlock, the Supreme Court ruled that a man and a woman who have been in live-in relationship for a long period of time will be treated as married and their child will be legal. In addition, the Domestic Violence Act 2005 provides protection to women who are involved in such relationships for a reasonably long period and guarantees them the status of a wife. In a recent ruling, Justice Arjit Pasayat declared that children born out of such a relationship are no longer considered illegitimate, and law favors legitimacy and opposes the crime of whoredom and adultery. Let's look at the rights of inheritance in live-in relations. In an undivided joint Hindu family, the child born out of a live-in relationship cannot inherit Hindu ancestral co-personary property, but can only claim a share in the parent's self-acquired property. A judgment of Madras High Court was set aside which held that children born out of live-in relationships were entitled to share in ancestral property because of the presumption of marriage. And an earlier ruling was reiterated by a vacation bench of Justice B.S. Chauhan and Swatantra Kumar, according to which, as a result of Section 16 of the Hindu Marriage Act 1955, legitimacy of children from void and voidable marriages, illegitimate children are treated as legitimate for all practical purposes, including succession to their parents' properties. In its operation, however, this rule is restricted to the properties of the parents, so they cannot succeed to the properties of any other relation. Children who are illegitimate can only make claims on their parents' self-acquired property. The Apex Court ruled that while a marriage exists, a spouse cannot claim the live-in relationship with another person for the purposes of claiming inheritance for the children from that other person's estate. It's not a live-in relationship when the husband is living with another person. It's adultery. Further clarification is provided that live-in relationships are permissible for unmarried heterosexuals. In conclusion, in the welfare model of living, the law does not prescribe how we should live. It is ethics and social norms that explain how we should live. Despite what the law recognizes as no crime, what is immoral may still be a crime, according to a 2006 judgment, which is now being notified by the court. Two consenting adults engaging in sex is not an offense in law, despite being perceived as immoral. However, such protective sanctions could potentially cause complications which can be otherwise avoided. However, raising the hammer may not be the best way to tame the brave and the bold. Creating awareness in the young minds is crucial, not only from the point of view of emotional and societal pressures that such a relationship may entail, but it may also lead to various legal problems relating to property division, violence, cases of desertion resulting from the death of a partner, and custody issues when involving children. As a result of the Supreme Court's opinion, it could certainly boost the confidence of more young people, since they would now be convinced that live-in relations are not unlawful. Only one can weigh the pros and cons, the impact of their decisions which will have on their family, and most importantly on themselves. Hope the information is useful. Thank you very much.